welcome to a new edition of the permanent seminar of the American Legal Association. In this occasion, we are going to be dealing with the right of work and privacy and in the conversation format. To give and welcome everyone, I'd like to mention to you we have the General Secretary of the Inter-American Social Security Institute, Álvaro Velarca Hernandez. Hi, Tere. Hi, everyone. Hi, everyone, for being with us. All the panelists, thank you so much. In the screen, I can see some familiar faces, and I want to thank you to be with us. And Jorge, Ulises Camarena, and Maria Victoria, Jorge Carmona, Maria Villa, Victoria Hernandez. I can read very well. Guillermo Diaz, Estela Venegas, and our peers from ISTE. How are you, Victoria? We have a pending matter there that hopefully we'll be able to progress on that. Gilbert, hi, how are you? And we have a pending matter to talk about. So I hope we can progress with that possible agreement that has us very happy. Federico Anaya, my dear Federico, how are you? And Happy New Year. I hadn't said hello to you. And Sofia Banegas Morales. Hi. So hi everyone. I am very happy to see you again in this 2024 and continue progressing with these forums and webinars. And I'm very enthusiastic. Thank you for being with us. And I hope this is a very successful meeting. Thank you, Secretary. And I also would like to introduce our summoning institutions, all members of the American Social Legal Institute, the Social Security of the Workers of the State of Mexico, ISTE, that is heading this commission, the Superintendents of Health and the Dominican Republic, the mutual associations of bodies for senior citizens in Argentina, the Information and Defense of the Dominican Republic, and the Guatemaltecan Social Security Institute and the Ministry of Social Previdence in Brazil. All the institutions that have made possible this event, I'd like to thank you for your collaboration. And I'd like to thank the support of the chairmanship of this commission. And to start with this conversation, I would allow myself to introduce Dianely Hernandez Lugo with us today on behalf of um, the Social Security Institute of the Workers of the State. And because of agenda, was not able to be with us. And here we are in this conference, and she's the head of services and academic operation of ISTE. Victoria she's talking about fifth ruler of Tlalnepantla de Paz and coordinator of social programs in the department unit of community services and part of the Social Security of the government of Mexico City. She studied pedagogy by the TESA Catlan, specialist in game psychotherapy, has a diploma, cares in development of alternatives, all of them by ATES Zacatlán. And she also has a diploma course in education, therapies, and therapy on alternatives and psychology. And she's having a master's on education planning and management in the professional development unit. We'd like to thank Dr. Victoria that was not with us, and I'd like to give the word to Dianely for a welcoming address. Good morning, everyone. On behalf of Victoria Hernandez Arellano, Chairwoman of the Social Security Institute, hello to our Social Security Secretary, Mr. Belardo Hernandez, a member of the American Social Security Institute. I also greet all the experts that have accepted participating in this conversation and all those that tune up this event under the permanent seminar of the American Social Legal Security. Everyone, welcome. And it is a great honor to start with this conversation that addresses two important topics: the right to work and privacy. I would like to thank each and every one of you to be part of us, and we hope to explore and make reflections about matters that affect our daily lives. And the right of privacy is one of the human rights that is basic, that gives substance to human dignity. We must acknowledge that there is an environment in the life of people that only concerns them and is reserved for the others. This environment is part of the individuality, autonomy, and the freedom that is admitted for all human beings, and it's there where you see the right of all peoples to keep reserved some aspects of their lives, and without their express consent, nobody can get into. In this sense, personal data are all the information related to an individual that is identified or identifiable, starting with our nationality, the physical location of the person. The data we provide within our working environments are very valuable because, aside from revealing data deriving from our professions, can reveal personal matter like the location of where do we live, our wealth, our tax and financial information, and certainly has to do with the rights of our intimacy. The right of intimacy is important for human beings and makes reference to the private life of people that are not part of public people and cannot be invaded by third parties, people or state-wise. Recognizing this right assumes the minimum basic conditions for human beings to be able to develop their individuality, intelligence, and freedom. For this, the International Work Organization, OIT, ILO, has protects labor rights worldwide. And one of the crucial elements in this environment is the privacy of workers, a topic that every time has been more and more important at present. The ILO has responded to these needs, but giving us a certain of practical recommendations that are an orientation forum to ensure the privacy of workers in the working environment. These recommendations, in spite of not being mandatory, acquire a meaningful weight because of the potential in order to influence the formulation of laws, regulations, and labor policies nationally and internationally. In spite of having national and international laws that establish general process for the treatment of personal data, the ILO acknowledges the need for personal information of workers. And this is in part due to the important transformation of working relationship that has generated new matters and challenges around privacy of the data in the labor environment. In a world that evolves very quickly, labor relationships are also transformed, arising new matters related to the privacy of data in this environment. And for this reason, this conversation is going to be a space for dialogue and reflection about tensions and relationships existing between labor rights and privacy. The sections of the section for questions is part of it. Please share your questions, share your experiences and ideas regarding these topics. And what are the implications of the right of privacy in the working environment? What are the challenges that we're facing to protect both rights in the working environment? And what are the mechanisms that would be recommendable to address conflicts among both rights? These contributions are basic to enrich our understanding and find effective solutions. On behalf of the American Social Legal Commission, we want to thank your participation, and we hope this conversation sets the beginning of a series of spaces dedicated to reflection about core topics related to social security and the well-being of people. With nothing further, I officially declare open this conversation about the right of to work and privacy. And we hope this is going to be very enriching and productive for all the people that are with us today. Thank you so much. Thank you so much, Dianelli. And this, the beginning of this conversation is formally being open. I'm Maria Teresa Gonzalez Nava, and I'm in charge of the legal part of the conference. And I'm also a specialist of this American legal social environment. Today, I'm going to be the moderator of this panel. With me, we have Dr. Luz Angela Cardona, that is the one of the specialists that is also going to be the rapporteur and has made possible to for this event to be possible. We're going to start with an introduction of the topic on behalf of Maria Villa from Buena. She studied law in Sevilla and she came out as a cum laude, her thesis, and she obtained the second prize in the School of Law in Sevilla with a PhD. She's a professor of the University Cardinal Center, the center that's part of the U.S. and responsible for the right to work and the right of Social Security. She also works in other environments in the Pablo de Olavide University and in the International Florida University, and authors of publications and books and magazine, part of some congresses related to the right to work, and member of the Research Center Technological Tension and Influence about the labor relationships. And with her, we have Jesus Luis Villalon. Maria would like to give you the floor. Thank you. Thank you so much. Good morning, good afternoon from Spain. And first of all, I'd like to thank sincerely the Inter-American Conference of Social Security for the invitation to participate of the right of work and privacy. And it is a true honor to consider me be part of this presentation that I hope is very interesting to you. So I'm going to share the screen uh, to see the presentation. Maybe I can open it. Can you see my presentation? Yes, we can see it very well. Reflections around the relations and tensions. So in my case, the what has been said, and let me tell you that I since 2019 I am a part of teaching and education. I'm not only dedicated to the working environment, but I'm also uh, uh, responsible for data protection. And in my professional environment, in parallel to the university, I have managed both facets in both ways. So from my perspective, I think it is very important that as essential matters, then so if we have an element that is so important, like the right of privacy, and talking about these first points, first, the perspective of privacy as a core right. Secondly, the risks that in this field have to do with the use of current technology, the particularity that this labor context has regarding the application of current technology, and the need of having a regulation and a specific control, not only in protection, but also in the working environment. So starting with the presentation of this right, I always like to start with something very curious. The first time privacy starts, it is very early. It started in 1990, and it started in the magazine of Harvard University regarding an article that two Boston lawyers talked about the problems in the intimate life that some personalities live. This is the first time right to privacy appeared in the United States, and privacy, in particularly where the privacy protection and the protection of data is practically non-existent, even if they pay a lot of attention at the privacy shield. In the practical arenas, the content is empty. In second place, we have the international arena in the UN. in 1948 with the Human Rights Commission, we gathered for the first time this right of privacy, intimacy, and this is an article of reference. And then in the Article 17 of Political and Civil Rights, they speak about it. And then in the International Convention in the Specific Labor Environment about the right of workers, Article 14 is also mentioned as of 2013. And I put it in cursives because since 1988, the UN General Assembly talked about it, but there's a pause. In 88, there was an observation of the High Commissioner about intimacy, and there is a pause. And as after 2013, when the UN elaborates specific resolutions to this environment, if we go to a regional level in the European environment, not the European Union, but the European region, we have the European Agreement for the Protection of Human Rights and Fundamental Free Liberties in Article 18, and the Conventional American of Human Rights in Article 11 also mentions it. And we make reference to the two terminologies that kick off in this conversation, and we made reference to intimacy and privacy because if we go back to the text, the first one, the first text that gathers talks about privacy, and after that, the UN is going to see this reference. And secondly, the pact speaks specifically about intimacy. The International Conference centers itself in privacy and in the environment, the regional environment. We talk about it indifferently. In the American environment, we see more privacy, but then many articles mention it in an indifferentiated manner. And it's very curious because in the European environment, privacy and intimacy is not the same. They're different terms. They're related. They do share some essence, and intimacy is closer to the individual. It's super protected. There's no possible discussion to forbid any type of differences. We can understand it as the address, the family. There is a discussion. Any international, regional norm, local norm forbids it in a strong and precise manner. Privacy is more important. It is a concept that includes different individual facets of the individual that considers in an isolated manner these things. So when these facets end up changing, they offer in a quick manner an information of the individual, a complete profile of the individual that without the authorization should not be known.
That difference of the terms is compiled in the European nation from step one. It's not the same to have like intimacy or privacy. The protection of people's intimacy is out of the question, but privacy is a must. That's how it's been necessary. It's been necessary to draft a regulation, the General Act of the European Council. The protection of people's privacy is tremendous with a lot of regulations that generate an impact. You'll ask why? Because if we see the multifaceted situations of the individual and the relations or the ties and the relevant information that can cause or harm or grievances, and you think about new technology makes us be capable of combining the multifaceted process and coordinate our efforts with the process of the use of technology. Big data enables us to compile, to cluster, to process, and fully treat the multifaceted or multi-layered process that leads us to obtain knowledge about private, intimate information of the person. With the use of technology, I mean, we could use technology for that purpose, for a purpose, but the use of technology is also a danger, and that's clearly analyzed in the European Union. For example, which are the risks when we use technology? We have to consider the following, and I'll center my discourse in the workforce today. Today, our societies have developed and used technology. Technology and its development is not something that you can halt. It's just accelerated growth, and that makes us use technology in a hyper-connected society. Any device today is issuing constant information via internet. That information is available. Second, that information, which is generated permanently, is cumbersome. It's immense. The information that I have here, I have 2 megabytes per second per person that's connected to internet. And there's a specific delay, there's a lag. And that information was updated 15 days ago. I know that today at the present, when every day passes, you have to update the information because you think about the number of devices that exist at the household, the devices that are used at the workplace, the mobile devices. You use those devices constantly and they submit or issue constant information. That information that's issued, it's mapped out in this graph that I use in my class or lecture of data protection. This codified graph is used by me weekly in my lecture. You see the amount of data that's issued if you analyze the use of each app that's used at the workforce. We see all of the apps that are being used and the connection of users, how they document the information and the information that they upload, that it's amazing. What happens? All of that information that's being issued or generated, and I don't want to use the language improperly, but that data that's generated, it's just data. So data that are being streamed or uploaded and administrated via internet. The data, I mean, it's a code, it's a binary code, it's a combination of one and zeros that's coded that way. What happens? That silly information, if you think of it as silly data, today, that piece of data could be used in a hazardous way. For example, big data technologies are being part of it, and artificial intelligence is also that we have to consider. So the data that's issued that's not bearing but ones and zeros bears wonderful and valuable information, and that data it's transformed into knowledge. So data, that information that's transported, are the most important entrepreneurial asset or corporate asset. And it's true, that's an asset. All the companies want to compile information when we develop a website, an interface, when we calculate or estimate what's happening in the enterprises or corporate entities. When we're connected to intranet of the company, we have to accept cookies as users. We have to access specific settings, configurations, privacy settings to give a permission to those other entities to invade our privacy or our private environment. So what happens? This new technology holds great potential, but they also have parallel risk. Even though we have like the private context of the person, the private information of the person that should be protected, those technologies can also breach and have access to the data. If we draft the policies of consentment to give this technology access, I mean, we have to limit boundaries of respect here. In the enterprise entrepreneurial world and in the European Union, I mean, there's entities that would not favor the implementation or enactment of laws that regulate this correctly. And that leads us to think about the risks in the workforce. And based on assumption, I'll speak about the risks in the workforce. We have to analyze the specific attributes of the workforce. The workforce is highly influenced and object of invasion by these new technologies. So the appearance or the creation of artificial intelligence, for example, is part of it, with the use of these famous algorithms that seem to cause hindrances or complexities in the corporate world. With this artificial intelligence, we have the specific traits or the classical traits detected of the entrepreneurial world or the corporate world. Companies today tend to decide to produce the information and fragment it, compartmentalize it. So even if they're dedicated to lending services as companies or other fields, they permit, or this permits or enables us to face the fluctuations that exist in the market if I diversifies. But on the other hand, some entities have decided to draft what's happening with our corporate world as a keynote. Today, today we there's many companies that are not betting on the use of the classical model of the fact that there's a tie between the employer and the employee in those relations in the corporate world to create or constitute that work. Due to COVID, many workers were working confined from home, like telework, and the numbers are still being analyzed, but there's specific proposals. And lastly, we have mechanisms to collaborate in the financial world of things. You think about the fragmentation of production and the mechanisms to collaborate and finance the process. What happens? What underlies? There's this tripartite tie or relation, and the employer is part of it as a stakeholder. And you see how it all squares off. The use of new technology enables stakeholders to obtain access to a limited information. Just a while ago, we can think about the limited access to information, the quantification of data, plus the combination of mechanisms that exist when you codify and create the algorithms to obtain the data, then it is a limited access to information. If I think about big data in the use of technology, then I can obtain the knowledge that I want to obtain about a specific field. If I want to obtain information about a specific customer or my structure, my corporate structure, that enables the company to optimize its resources without precedent. I'm speaking about material resources or human resources. That has led productivity at an entrepreneurial stage without precedent. I mean, it's something that's happened that's never been seen before. And lastly, I want to speak about the next layer or facet. In this next facet, I'm going to analyze the challenge. The use of technology enables us to continue monitoring, surveilling, and keeping control, an enormous level of control, monitoring and surveillance of production, and there's tracking and traceability of that production that had no precedent. And we can keep track and control of human capital or human resources. And you think about the flexibility. When flexibility is another ingredient, you see what's production. The capacity to administrate a company or the world of enterprises declines with the flexibility given to human capital or that organization and structure. And you think about the control, it all works hand in hand. So there's a decline in the powers of the organisms, but if you don't need to have your human capital present physically at the company, at the headquarters producing, I'm allowed to keep my human capital or human resources working from home with greater levels of control because I can't see the person or the worker from home. I can't control the worker under specific conditionals to use the platforms or the company. I can control the worker remotely because I can geolocate that person through the mobile devices. I can control the time of efficient use of the device. If they're only using it for work purposes or the user is using it for his or her own benefit, I can control the vehicle of the company, the miles, the mileage, the journey. We can see that and analyze the controls of these journeys in Amazon. Think about the controls in Spain, the routes and journeys of the delivery men or people in transport, they control those elements. The use of this technology is also has another ingredient that's relevant in our field. You know what's the general scope? In general, the use of technology and technologies are being used in many companies in all the fields, irrespective of their scale or their dimension or size. The use of this technology is low cost and easy to use. So, and you see the next graph, I'll highlight the specs. First, any company, even if it's an SME, small or medium-sized enterprise, they can develop the use of technologies, apps, or other tools. And the devices are connected to internet, to telecom, and they're constantly issuing data that's used as information, relevant information. There's devices being used with specific plans to, and with the devices, they use apps, a mobile app, a vehicle for the person to execute their journey or work tools. in a broader sense, in the labor world, you can use your message or text message systems or apps, or an internally developed app to communicate via text. A second element, this technology is available for anyone. I mean, it's relatively low cost. You can buy a device at a very low cost. It's factual. It depends on the cost and my cost efficiency, but that device is going to be used for work purposes with a personal computer, with a tablet, with a mobile device, under any circumstances. And that investment is not a major purchase. So if I want to develop a specific app, I want to have specific powerful servers, and I don't want to have them in my headquarters. Maybe I don't have the servers in my headquarters and I want to have the stored servers in another location. So we have that clear example of Amazon. I can rent the Amazon servers and I kick off my app and my process and execute everything and store my data in the cloud. I don't have to pay to have a server physically, a huge costly server in my company. I don't have to pay for firewalls. Amazon can lease it and lease their servers. You see the specific knowledge that it bears. I can hire a third party, another entity that administrates my technology, my IT controls, my app controls. I don't have to implement it internally or develop it internally. That's the way in which these services are fragmented. I have IT services, there's third parties that could provide that IT administration, and they have like material resources and technical support teams. If I escalate and keep my data in the cloud, I can use servers from Amazon. I don't need to have or buy the capacity or physical space to have the memory and tools available for me to execute the tasks that I have to execute and obtain the information that's relevant for my purpose. All of these factors make the general understanding of technology nowadays in any corporate setting correlatively, it needs to be also adjusted or customized. Those are notes, and that is also affecting the workforce. On the other hand, the apps and the use or the implementation of technology, if we concentrate our discussion on what's happening in the workforce, they lend a service and they lend a service using tools or devices, material resources used for work, and we have the mechanisms of control. We have control over audiovisual devices, geolocations, video cameras in the company, geolocation devices. There are very specific material resources that are devices that have a clear objective. The objective might not be the geolocation or tracking of the person. You can geolocate the mobile device that enables a company to see who's the owner of the thing. For example, that device could be used exclusively for the user to call a client, but the company could analyze what's happening with that device and determine where the person has been located specifically as an employee. So you have access control devices, biometrical data to have access to check in when you have your shift at work. You can input your fingerprints to see when you've accessed or left a restricted area department, or you can have your iris or your eyes read. And lastly, another point that for me, according to my perspectives, that are really complex and dangerous is the use of the compiled information, the personal private information that the company might have access to in automatization treat the data or administrate the data. It's very dangerous for a company to develop or executed specific tasks or services. There's an employer and they pay at the payroll of the employee and must guarantee the health and safety of their payroll of their workers. So they have to have access to that personal private data of the users or individuals. They might not ask the worker for permission to have access because it's implicitly in the payment of the payroll. So the employer might have access to the current account of the worker. They have access to the personal data of the address because it's stipulated in the contract when you hire that person. You need to have access to the telephone if the company needs to contact that person directly. So all of that data is something that the company obtains. Yes, but there's specific information that the company should not have access to and should not be used either. For example, information of the family of the worker. For example, in revenue services, to pay taxes or contribute in Spain. In Spain, we call it IRS or IRSP in our acronym. To know the percentage of payroll that I have to keep aside on withdrawal to pay taxes, I have to know how your family is constituted, how many members constitute your family. Are there minors at home? Do they depend on you? And all of that private information that I should exclusively use it for tax purposes, I have to see what's the percentage of tax that I have to discount from your payment of the payroll. I can use that information as a company with other objectives. I can obtain information from my whole roster. I can see how many women are hired in my company and their age ranges from 24 to 40 some in the corporate world. I can see if there are women that can produce a child. Maybe there's child-free people in the company. And if I analyze my big data, I can obtain predictive data and specify that specific workers, female workers, will schedule and calendar their maternity and they will leave my company in 3 or 5 years. And that's not acceptable. Those trends that are analyzed automatically to go through an automatic decision-making process that's executed by artificial intelligence, it's a very dangerous tool. And in the workforce, there's a lot of issued information that the companies have access to do their job, but it should not be used for other purposes. And in the European Union, we are drafting the rules and acts about the use of artificial intelligence with the authorities at the council. Lastly, all of these comments correlate to the fact that we have to draft our general acts to regulate it all. We have to analyze the legal realm of things, and law is always the response mechanism. Law is always delayed. Drafting a law is the possible response and solution to the problems that our societies face, something that's taking place in material now, and we're trying to give solutions to problems that happen now with law. In the field of technology and IT, when we regulate with our law, we try to anticipate, but technology is accelerated in its pace of growth. That's almost impossible to draft laws to protect. In the European context, we have passed a law to analyze all the implications and all the situations that will arise with the use of artificial intelligence. With the Act of Data Protection, we try to protect personal data, and it's object of amendment constantly. And we're trying to advance and anticipate ourselves to cases that can take place. When we develop technology, we have to be sensitive enough to think about the abysm and the delay when the solution is the law, and amidst the development of technology, there's still that gap or delay. And the usefulness of the creation or drafting of laws in that specific field of law, so it's object of debate, and we have to debate these initiatives in less time. So we think about the enactment or enforcement of law within a reasonable time. We have to analyze the law to see if the law is a solution to the problem, because technology grows and its growth is accelerated. So we have to go through a process of amendment with a collegiate body of experts to narrow the gaps in the law. And it's the response mechanism, and law is always late. So that's what we've observed. We need to have the capacity to control those technologies and the traceability of it. Tracking things gives us the capacity to obtain clear information. So the laws and regulations should be very specific, naturally, in the workforce, and it's a must. So we have to draft the law to protect the workforce, and that's not a matter of debate. Second, we need to enable companies and institutions to know what they can do and what they're banned to do, which are the limits. Because when you build the employer and worker relations between companies and the workforce, and the labor acts and their spirit in the general acts protect the worker strongly, but the companies are also subject of rights to be exercised, and the corporate parties are also protected. Both parties need to know where the protections are, and who can suffer a greater grievance in their rights is the workers, but the companies have to have clear limits outlined about what they can do and what they can't do. And in the field of, in context of technology, we have a margin, we have that leeway for us to stipulate what's the base ground of the acts of that regulate these relations, the employers and workers through the representatives and the collegiate bodies in the companies. They can negotiate in collective the right thresholds of action within the lawfulness. And that's really interesting because in our general acts and laws, we create them for the general solution, but then you think about the specific cases that each companies will face because they know their payroll, they know their workers and the type of activity they execute. So the parties involved should be capable of reaching agreements in evil fields. And with this, I finish my participation. Thank you so much for your attention. Thank you so much, ma'am. Thank you, Miss Maria. Doctor, thank you for your very interesting presentation. Let's continue analyzing with the proper dynamism our discussion. We will start this next phase of today's exercise, this tangible exercise. This is a debate amongst the collegiate body of examiners or experts who will all present to you. First of all, we have the presence of Dr. Jorge Ulises Carmona, who is a doctor of law through UNAM. He's also in the field of justice administration. Also, he has more accreditations of UNAM. He has an expertise in international law, thanks to TESx University in England. He has the Alicante accreditations, and he also has accreditations from the field of Amparo of Iberoamericana University. He has many accreditations. He has a law degree through UNAM, and he's worked in human rights for the Inter-American system as a consultant. He's also a professor, conference member, and he's been working abroad. He's also working at National Autonomous University and an observer of the National Commission of Human Rights in Mexico. He is in charge of protecting the economical, social, cultural, and environmental rights. His fields of expertise are national and international protection of human rights, interpretation of legal cases. And with this basis, he has experience in international litigation and human rights cases. Welcome, Mr. Ulises Carmona. It's an honor for us to have you present today, sir. And I also present Dr. Estela Sofia Vanegas Morales. He's an attorney from Javeriana University, an expert in financial law from the Andes University, and from the Catholic University of Lovaina. She's an expert of law through the accreditation of the Alcala University. He's also into trade law, digital security, accreditations. She's also a member of the stock exchange of the and part of the collective collegiate body that works to the protection of data, ADAPI, in Colombia. She's the chair of the LATAM Committee of Privacy Rules and co-chair of the Knowledge Chapter of the International Association of Privacy Professionals. She's also worked with Seguros Bolivar. She was a VP of the many entities of government, legal department lead of the financial entity of Colombia, and the attorney also for Experia Data Crédito. For the past 11 years, she's been part of the law firm Vanegas, with the protection of personal data, trade, and the use of new technologies. Welcome, Ms. Stella, for this to be part of this debate. Thank you all very much. So I'll also present other institutions that constitute our membership. It's an honor for us to have the presence and the support of the following institutions. This debate gives us the opportunity at a continental scale to get to know which are the institutions which are part of our membership. I salute and congratulate Mr. Federico Anaya Ojeda, who's here representing the Latin American Institute of Labor Law and Social Security Law. He's a member and a liaison member. He's achieved his degree of law National Autonomous University. He's also a professor in administration with Del Valle University. He's also working on his PhD at Anahuac University. He presides the Anaya Valdepeña law firm that was constituted back in 1932. He's coordinating many efforts with a chamber of the industry and part of the bar of attorneys in Mexico. He's a member of the panel of arbitrage and works with Concamin and many chambers of production in Mexico. He is the general attorney of the chamber of different developments in different fields. He's also a representative of many entities in the automotive field. He works with many SMEs or small and medium-sized entities or enterprises. And thank you, Mr. Federico Anaya. Thank you. It's an honor for us to have you here. Thank you very much for the invite. And last, we have the representative of the Union of the Costa Rican Workers. We have the president of Gilbert Diaz Vasquez, representative of this union, who has his degree in administration, public notary. He has a degree in law. He is now studying a master's in structural behavior. He has many accreditations in politics and in the administration or change management. He's been part of many conferences in LATAM about values, principles, society in Costa Rica. He presides the Union of Workers in Education at Costa Rica called SEC. He presided the Popular Bank for national development in his country. And he was part of the Collegiate Council of the Bank for Financial and Community Development. Mr. Gilbert, thank you very much for being part of this session. I congratulate and salute everyone. Thank you very much for considering us as part of this debate in this important communication. So specifically, my field of expertise is solid in a labor law, and I just wanted to stress on that point for our purpose, which is analytical. Thank you so much, sir. And as I mentioned before with our previous panel members, in this phase of discussion, we have three core questions, these essential questions. And with our questions, we want to have a robust discussion amongst the collegiate body of experts. With these three basic questions, we have the following dynamism. I'll formulate the question, keep record of your replies or answers. Please give us three answers so we can continue developing the rest of the questions, and there's going to be a response mechanisms if somebody wants to contribute. The first question, and I'm ready to keep record of the first participation. What does it what is the access to privacy, or what impacts or effects could access to privacy have in the workforce? I could keep a record of the participation or reply of Mr. Ulises Carmona. Second answer will be received by through Ms. Estela.
Okay, and then we're going to start on third place, Dr. Federico. And once the three of them conclude, I would ask if there's any replica. Thank you so much, Dr. Lee says. Remember, I'm going to raise my hand when you have 30 minutes, 30 seconds, as soon as I raise my hand. Thank you so much, and good afternoon, everyone. I hope everybody has a great day. I believe, and I'm going to give you a first step to start putting order to these such important topics that are so wide. And then, as we saw it from Dr. Maria Villa. So now the fact that it's human right is not something minor, and it means that is associated to human dignity. And this minimum that is irreducible, that gives us an intrinsic value and distinguish us as a species. And in this sense, pointing out and getting into this topic from the perspectives of human rights, I believe that is getting through the right door. And it has a series of very important implications. And what the topic of human rights has and all its contributions in each of the area where it's presented includes many, things. And first of all, it would be dealing with human rights. This is universal. And it means that the only condition to be acknowledged, per se, this right to be acknowledged, is being before a human being. There is no other condition in order to be the head or the owner of rights regarding, in this case, privacy. Another aspect that these perspective has is that human rights are intertwined. In other words, we're not going to be able to isolate the topic of privacy without considering other rights of the same people or the same person or other people individually or collectively. And the third aspect would be the fact that human rights are not absolute. And every time we comment this type of matters, sometimes we have a position that has some concern that say because we're before human right, everything is valuable. No, the other way around. Talking about a human right and its exercise means the possibility of establishing limits. And here the core topic is where do we put these limits? So every human right, as we said, is not absolute, is susceptible to be regulated. And in this sense, we have to know up to what point can you bring these rules or we can establish in human rights what is known restrictions that are legitimate restriction to these rights. And in the labor environment, this topic, if this topic is brought to this matter, is going to have as a central topic the possibility of establishing a series of rules to see who is going to do the surveillance to abide the laws in order to find this point of balance between the right to the basic nucleus of rights to that goes into what's decidable and negotiable and that is also part of an area of the no that something that cannot be decided, this central nucleus that you cannot renounce to it or it cannot be negotiable in any aspect. That is going to be my first comment. Thank you so much, Dr. Lee says. And now I'd like to go to the answer of Dr. Estela. The question is, what are the implications that the right of privacy have in the working environment? Thank you so much. And I congratulate Dr. Maria for her fantastic presentation. It gives us very interesting elements and in order to answer to this first question, what are the implications? I agree completely with Dr. Lee says that we're talking about a basic right, and this basic right requires a greater level of awareness and a greater level of appreciation when we're going to face any aspect where we have to impact these rights. And this core right should be in balance with the rights that companies have to develop their own entrepreneurial activities. We cannot talk about the right of law if we don't have companies and if we think that companies don't have any legitimate expectation of being able to deal with certain information for the development of their own activities. So if that is our first element, we also have to agree that we live in a digital society. In it, we have to look after our information because many times our expectations are very high that they look after the information. But as a person, I don't care for the information. So I demand privacy in the work environment, but I'm totally disordered in my personal environment. I put any type of information to social networks. I share information about my children. I publish data of my employee, of my peers at work without having any type of caution. I never ask if you can or you can't. And many times in information, I don't have any awareness of the risk levels at the same time that I'm making use of this personal information. So among these implications, I think that we have to have a balance where the employee also needs to be informed, also has to be trained, and also has to be sensitized So why would it be important for the company to use or not the information? Not everything is going to be necessary or reasonable. So if we base ourselves that there's a company that is looking at the end that they could make use of personal data, they clearly defined what is the legal right and what are others that are necessary and core to comply with the law, and they're needed for the development of the business, and they have to inform and to provide warranties about being accountable, having certain accountability of how they are exercising it. So here we're going to have a relationship that's a win-win situation when the employee understands and wins is more cooperative, when I can transform the information based on ethics and quality about what I need, and I can try to do regarding data processing. We're ensuring also these things, and there I would close that the companies have to do these exercises that are so important in order to identify what is needed in my company's environment regarding personal data of these employees that I have and me as an employee. I also have to check what does this company do regarding privacy. And if I ask a lot of employees, have you read the privacy of politics, the policy of privacy in your company? They think this is a document that to comply with. We are not here to comply. We have to comply. As a matter of fact, that we have to be very with great details to comply in depth. So this would be my point to be mentioned right now. So, Dr. Estela, thank you. And I have the last participation registered before the replica for Dr. Federico. Thank you so much. And thank you, Assis, for the invitation. Congratulations to Maria Villa for her fantastic presentation. And of course, my peers, Ulises and Sofia, for your participation. When we talk about the right of privacy in the working environment, the right to privacy, we have to take into account one of the first things we talk about fundamental rights, we talked about big data, new technologies, but what we have not spoken about is that at least in Mexico, the last in the last reforms law related to labor in the last few years talk and protect a other than people that work at home, not small employers, but older and senior grade employers, such as Amazon, such as these large companies that have lots of technology. But they don't talk about SMEs, small and medium sized companies, and 99.9 or 99.8 percent of companies are small and medium-sized enterprises. Therefore, as mentioned also by Maria, technology has reached all the corners of the universe, or almost all the corners of the universe. It's as easy to have a control of an SME through the core center and applications that we have that are very common, talking about WhatsApp, Google Maps, that do not require lots of investment. So the right to privacy regarding workers has been legislated very poorly in Latin America and Spain differently, in a way that's specific, in a way that is generic. In Mexico, there's a federal law for data protection since 2010 that talks how do we have this data protection data that become this structure in an information. So the first thing that we're looking for in the protection and the first impact is the first implication that the right of privacy has is the right of human dignity. That's the first thing I look to dignify the person, look and make sure the person is dignified. And for that, we have a legislation in the OIT what dignified work means. The second implication that I would feel that I should mention is the monitoring and surveillance. Employers can implement monitoring media or methods or surveillance, and these measures can be provided not to invade this fear that we were talking about. The line between privacy and intimacy is very, very blurry. The third impact would be controls of electronic communication. How are you going to control in electronic communication? Companies many times monitor communication, electronic communications, but do not classify if they are or not relative to work or not to work, or if they are intimate or private. Another impact that we have to look after is the classification of this personal data and sensitive data. So we can comply with privacy data and data protection data, but it could include information such as medical background, like financial details, like any other type of information that could end up being very sensitive. And it should not be inside all of this data. And the third one or fifth point would be medical records. And sixth is access to social media. Some companies can check the profile of people's profiles thinking that is something normal, but the employee could feel that they're not happy if the employer, their employer are checking their social media. This is not private, it's public, and they complain that he's checking, he's stalking them. He's a stalker getting into people's social media, even if that's public information. So this, I feel, is one of the most important is consent, and consent, informed consent is so important. Employers many times are looking and requesting consent of employees to to ensure the environment where they're working is healthy, very healthy, and the respect, the trust to privacy, and they talks about well-being of workers and well-feeling of workers. And in order to finish my point, and the last point is the working conditions and going back, or the work environment, a healthy working environment that we're looking to ensure the privacy of employees, and that contributes to the creation of a healthy work environment. And with this, I finish my presentation. Thank you so much, Federico. I had Maria that wasn't able to raise her hand before. I don't know if she wanted to participate as a replica or participate in this first stage. Then Dr. Estella, and if you allow me as moderator, after these two interventions, there's a question aimed at Dr. Gilbert that we invited to this panel for the vision of workers as part of a union. So Maria, please go ahead. Thank you so much. I don't know, the hand didn't stay up, and that's why I put it in the other chat. So I wanted to tell you that Ulises, Stella, and Federico's interventions stress essential aspects of these, and one of them that is in particular relevant, or two of them are so relevant. First of all, having the possibility of getting to know the framework of the game framework for workers and enterprises and workers, and the second one when they talk about social networks. And here we have a lot of cases of the use of this inquiry on the social networks, and they see the profile, the public profile. So we have this peace of mind that this environment is untouchable, and there's companies that are making decisions because of the information that they can have access because of this public environment of the social networks. So we have to find a balance amongst both facets that is provided by this privacy policy that has to be implemented by companies. And the best way is not a document because they should, as mentioned in the European Union, there has to be a active and by defect responsibility. The company has to anticipate to the inquiry of the worker, and the way they have is not elaborating some behavior or acting. No, there's no parameters that companies have to have, but they have to be accountable regarding data protection. And here, for example, they demand an impact evaluation. This demand is for their own specific public administration and companies that are dedicated to the massive information of data, that the main work is the massive data treatment. And beyond that, in the data protection environment, all data protection people say that we have to check the social impact. So before when you have data protection, you can find that they're carrying out a responsible behavior regarding personal data protection, and that they take into account this possible invasion not to do it regarding the privacy of employees. Thank you. Thank you, Maria. Now, Dr. Stella. Well, thank you so much. And all the analyses are fantastic. And then we have this will of participating and complementing. I would say four things that are very important in our region, and that set a difference from what happens in the European Union. Most of the countries in our region are based on consent. This is a treatment that it's legit. We have the consent of the holder. We don't have the expectation that exists under the GPA rules. So this leads us to, as mentioned by Dr. Lises, to we have a tension. Why? Because on the one hand, we know that in a work environment, there's subordination. If I tell somebody to allow the consent to determine if we can go in or not to their information, I'm facing to be enough transparent enough and not to see adverse consequences if I'm providing consent for non-indispensable activities. And the critical point is knowing and being able to identify what is necessary and how do I communicate it. Secondly, I think in the topic of uh, looking at the information that exists in social networks, there's cases in the US, and I'm sure it happened to you in the case of Carpenter, where there's an expectation of reducing the privacy on behalf of the person or the labor. So we have very complex phenomena such as corruption, and we have to try to prevent our employees to incur in practices or succumb regarding a practice that is against the law, implies fraud or corruption. And there's information that is public information that can be accessed in order to comply a legal level. And many times we have the companies that are, they tie their hands uh, when there's a person that they uh, are not going, so they appear in 20 publications sharing private spaces. So it's kind of, we have to be very realistic. We have to look at the reality of things. And if there's a reduction in the privacy expectation, the data is contained in a public profile, maybe there should be a warranty. This, if I'm complying a legal duty and I'm only going to use it for that end, it should be allowed, I consider. So I would close with that, and is that the previous information is key. And I agree with training to SMEs because they need so, the small and medium-sized companies. Thank you, Dr. Stella, for your participation. And now that in this first participation, the topic has come out of what are negotiable, what things are not negotiable regarding this clash of rights, and also the topic of having a clear framework and the consent of workers. I'd like to ask the chairman, Gilbert, if this has been a matter of the Education Union group in Costa Rica regarding data that happen in institutions, in this case, in the education environment. Thank you so much for allowing me to participate with you in this topic that is so important. We talk about human rights, but these are human rights that are so complicated. First of all, I'm going to say that the right to privacy at work is a core declared right related to privacy, but the right at work, we have to control the balance, the right equilibrium. It is true, on the one hand, that in the international rules and regulation, like in the country's regulation, exists and is established by the Constitution also, that we make reference to privacy, data privacy. But the political constitution, and we have the law of data protection, and in some of the penal law, they speak very generally, but also at an international level, we can see human rights. And human rights is established in Article 12. We establish and we acknowledge the right to privacy and protection of people and families. We also say that in the European Convention, in its Article 8, talk about the right of private life and family life, and general rules or regulations that have to do with agreements of different countries where they talk about it. But I feel that today we're saying that this is a right, that the labor right that is unserved in the working environment for the workers as well as for the bosses. And we all agree, as I've heard the different presentation of the development of technology, where we have to be very careful, because all of this is part of labor rights that are not specified in a specific law, and they have its contradictions. And we say this is a topic that is not in the jurisprudence or the doctrine in our case. And what we've been able to review at a Latin American level, Central American level, North American level are scarce. Scarce why? Because the norms that come and protect privacy and the right of workers. And what are we doing? What are we doing in this framework? Because in order to create a specific law, we would have to get into all the we get in trouble, and without being reiterative of what others said, we have the problem of technology that gives opportunities to workers, but all of these could have important repercussions. A violation to these rights could have important repercussions, personal repercussions. It could have lots of components between the employers and employees because of this freedom that could happen in our case here today. And I like to go to something that is being represented in education. Today, we are at the right time where we're in a negotiation, because there we could end up having this balance, because there should be a balance between what do we look after? How do you look after? We have to work in the consent, because if not, we could not continue progressing. But how do we control that? And I said that some problems occur, and we in the company and among the workers and the bosses. So there you can have, for example, claims against the rights of privacy. And here we could say the the uh, the problems start with between employees and employers, and some and how do we protect this relationship. So I would say it in education that today we try to be reaching agreements. We are in a ongoing negotiation of the collective convention, and through and here is where we expect to be able to introduce some articles that would allow us to regulate and look for this balance between the right to privacy as well as the right to work. And this is where we're at present. Thank you. Thank you so much, Gilbert, for your intervention and your perspective. Now, I would like to go to the next question, and I'll register the participation at start, and then with the answers, I will register the replicas. The second question is mainly focused on the challenges being faced in the working environment in order to protect both human rights. Who would like to participate in this round?
First of all, we have the responsive Ulises. Second, Dr. Stella. Third, Miss Maria, Dr. Maria. And Mr. Gilbert also. First, I keep a record of the participation, Dr. Ulises, then Stella, Maria, and Professor Gilbert. Thank you, Dr. Ulises. Please go ahead, sir. Yes, for the to answer the second question, as we've already discussed, there's no doubt left about the fact that we acknowledge the fact that there's the right to have privacy, a private life, and that intimate private world, and there's rights that are binding. We must protect data such as the person's address, communications, etc. In amongst these lines, the in this debate, I've been listening to all the participants, and in alignment to the question that you formulate, we have to answer the question now: how do we do this? In that sense, with a perspective and clear understanding of human rights and public rights, we must find ways to help. And with these lines, we can also contribute. And I refer to the subject everything that's restrictive or all laws or the regulations that or what norms or regulates human rights coexists with its characteristics, with their specifications. Any restriction to rights or any restriction to rights has to be supported or substantiated or on the grounds of law. I speak in the formal world and in the material world of things. Implicitly, this means that the states, that the organs or the administrators of justice and the execution or enactment of law, these authorities have to safe keep executing their duties. There is a specific frame, there's the general lawful frame that has its outputs, and the outputs are the feasibility of being restrictive. Another requirement, and I think that we have to focus, concentrate on the provisions which are restrictive. And so these are lawful and in alignment with laws. Third, any restriction or is necessary based on specific criteria or rulings of the human courts law. So it has to be humanitarian, and the impose if you impose a restriction or a ban for something, you have to see what it satisfies. There's a need and there's a protection of the right, and the measures to protect the rights that have to adjust clearly to the legal objectives. In this sense, we see from the perspectives of human rights the specific parameters or provisions that could give us light and guidance regarding the norms that must be drafted. If not, if we don't observe this, we can generate a secondary problem. There is a lack or gaps in the legal and lawful world, because then we don't know what could happen at the end of these labor relations, and that would have an effect, as President Gilbert just mentioned. Lastly, this would make parties confront and litigate before courts and tribunals, raising questions or formulating questions, being admitted before the authorities or the bench, uh, because you have to justify if somebody's dismissed as part of the workforce. Any violation to human rights is part of our analysis, and it demands a thorough assessment and investigation. At the time being, when there's a penalties and sanctions imposed when you think about human rights, and then there's needs for us to adjust this. It's possible, in another session, we might know exactly which are the documents, the working documents that are the guiding instruments, so we can continue working on our endeavors. Thank you so much. Thank you very much, Dr. Ulises. And please go ahead, Miss Stella. Perfect. I will be specific and punctual and focus my reply in two and four elements. We spoke about the challenges that are formulated when we adopt the use of new technologies. So I believe that something that's key here is for us to clearly identify or classify or have categories of companies and analyze the needs when they're hiring, the corporate needs when they hire the use of these new technologies. And we have to know exactly which are the entities that are providing or being the vendors or supplying that new technology. Not all vendors are as aligned with policies, laws, and regulations, nor international standards that protect privacy. Many mistakes have been committed. Many companies have gaps or security and safety deficiencies because the technology or the software that's being object of procurement had a lack of capacities that protect the people's information that should be safe kept. So, yes, I'm in favor of using new technologies, but we must identify first what's the purpose of the use, who are the third parties that will provide that technology, and how will I control the use of those technologies and the development? Because they can store the data of my companies, that third party can have that control, but when the contract is not valid enough, then I should be the sole entity that could receive that information under that constant monitoring of the execution of the binding agreement. Do I have red flags, specific warnings that I have to keep a close watch on? And we see those challenges. We have to contractually stipulate that these entities should be object of a clear observation and audit to see that they're in compliance. Regarding the other comment, we have to guarantee the workforce, the workers, the employees, that their data is going to be confidential and private because they have the right to exercise their data protection rights. They will not be object of retaliation, and that's very important to keep archived and document all the processes which are of public domain. On the other hand, we here speak of how do we do things, how do we work so the employee as a stakeholder is not surprised when he or she uploads or posts personal family information and the devices that have been given by the company to the worker as an employee. So we have to train our HR departments, our human capital departments, and those stakeholders which are part of the process to tell the worker, the employee, that in his personal work device, he cannot store personal family pictures or have the total clear title or heading to that case, that file that lives in that device. If it's a work device, I can't store images in which I can reveal intimate or personal data or data of my colleagues. So that we have to previously inform the employee, and the employer have to know that they could be object of an audit when there's a case that requires and demands the audit of those devices. So there's that, if there's no room for doubt, it's like if the parties are not involved or informed, it's like they can't argue that they weren't knowledgeable about what they had to do. So we also have to allocate a project to specific allies at a corporate setting. There's many companies that shared with third parties corporate data. We have to be highly judgmental when tracking and monitoring data. What data are we sharing? Which are the risks that we have in advance identified? And how do we control the risks to go through the proper assessment? Thank you very much, Ms. Stella. Thank you, Maria. Ma'am, it's your turn. Well, when you formulated this question about the challenges that we're facing all in the work environment, in the workforce, first, I have two comments. Raise awareness be very mindful. The parties have to be willing, and all the stakeholders have to be willing to understand and be knowledgeable about what each party has to do and is responsible for it when they protect their rights. This has to be a positive instruction to be in compliance with a norm, in that room of collective or negotiation or class action negotiation, as Dr. Gilbert said. So it's a broad field, it's a broad sector because we have to be flexible in a process of adaptation, and we have to think about the specifics of each company, of each enterprise. And that's part of the challenge. And another challenge that, based on my observations, it's very interesting, it's to find the mid ground of balance, that equilibrium that's okay for the employers and the workers, for the corporate stakeholders and the workforce. In this midpoint and in correlation with my comment, I've heard what Dr. Elises and Stella said. They aligned their comments to what's proportionality. We need to find balance with the clear objectives of the company and the means that they have available to achieve their objectives. So there's a need to find the right proportion of balance. Both stakeholders or employees in the companies will obtain what they need, and the companies will obtain their objectives, and the protection of the employer's rights is a must. But we have to know which are the clear objectives that we're trying to achieve. If we don't understand the achievable objectives, then we can't create a formula that's adequate for the parties involved, for one party or the other. And what Stella just said about the use of mobile devices as an employee, I could be given or allocated a mobile device by the company, and I can use it as a worker to take pictures of my family members. But here we have to know that it's mandatory. When the company facilitates a device to the worker for his or her execution of the job, they have to draft the internal law or protocol. The worker knows and has to be informed in advance regarding what she can do with that corporate device. And if the company allows the worker to use that device for personal objectives, and the company might control and be in constant monitoring and surveillance of the information that's stored in that mobile device of the employee. So the person defines the level of invasion in the personal life of the user through the company's eyes. Thank you so much. Thank you, Dr. Maria. Now I have here the record of the participation of our Dr. Gilbert, and Federico also raised his hand. In a moment, the floor is yours, sir. Professor Gilbert, I just want to remind you that when I raise my hand, you're going to have only 30 seconds left to conclude your contribution, sir. Please go ahead. Please. Okay, pardon. Okay, so you're gonna give me like 30 seconds warning. My God. No, sir, when you have 30 minutes, 30 seconds left after you start formulating your reply, then I'll raise my hand. That means that you have 30 seconds left, sir. Okay, thank you. We have to keep controls about the fact that there could be violations. A violation should not be a misuse of power of the employer as a stakeholder. And I think that we all agree on that point. Mainly, we're speaking about control. And having that control is something that's redundant. And how do we keep that balance amidst that control? I mean, there's reasons and motives, and we can say here, if you violate the privacy of an employee, then who said it before? uh, Miss Stella, Miss Stella said that we have to draft a protocol or give proper instructions to the employees as the workforce. We have to give them the instruments and tools or knowledge. The employer as a stakeholder has to instruct the worker too. So if we can't regulate, codify it, draft it in the labor acts or the amendments of law, we have to sit down at tables of discussion. If it's a negotiation in the collective, we have to draft a specific general internal act of the company in which the internal law of the company dictates the conditions and protocols. And all the stakeholders should be completely informed. The employee as a stakeholder knows the instructions or the internal law of the company. Here we can't keep secrecy or have anything in corporate or entrepreneurial secrecy or surprise any stakeholder involved. So we have to negotiate, reach specific agreements, outline perfectly the responsibilities that and the rights that the employer has when the entity has to exercise its rights through the analysis of email inbox scrutiny, or the cameras and the recording devices that they have could be object of scrutiny. That data should never be absent. It should not be like a loop. We have to analyze the conditions. We have to draft protocols or those internal laws in which the stakeholders know how all of their duties will be executed. We have to draft a code of ethics. And in that code of ethics, those laws coexist and it binds the parties or stakeholders involved. Because when we speak of data privacy, the data has to be totally transparent. I mean, we have to administrate that privacy with transparency. And if there's an absence of law or loops in the law, we have to work with technical groups and give this project the right line. We have to create the proper labor environment that's enabling entities to participate with tranquility. Because if it's not drafted right, if it's not drafted right and outlined right, it becomes an inferno. It could be hell. And what our core interest is, I mean, the parties, the employees have to guarantee their productivity, and they have to continue monitoring and surveilling their production or what they do in the best way possible. And what I'm saying is we have to see which are the common specifications. There's trust. There should be an element of equilibrium with the laws that are drafted internally for the companies to work so the employees can reach bilateral agreements or it's a joint endeavor. And what's of utmost importance here is that there has to be, we have to work in peace and tranquility, and the production of those relations between employees and employers could give us the proper output. So it has to be discussed by the parties or stakeholders involved. Thank you so much, Professor Gilbert. Now the floor is open for Federico. Please go ahead, sir. Thank you. Thank you for calling me Federico. I just love it when you just call me Federico and just stop, the titles and all of that nobility. But thank you for just calling me Federico. And I could be here you discussing so many subjects, and I don't have more than 5 minutes. But one of the issues are the somebody mentioned the use of cookies or accepting cookies. Cookies is when you click on a cookies button, you give your consent, you accept. That's how the major corporations can use data or obtain data to, and that data is used. Maria, and correct me if I'm wrong, Maria, but what happens when you accept cookies? You access a website, that interface, you see which cookies do you accept, which cookies you will not accept in the best case scenario. In the worst case scenario, some interfaces or sites will not ask you if you accept their cookies or not. But if you don't accept and click on the cookies button acceptance, then cookie sounds beautiful, right? It's like cookies, cookies. But as a user, you're enabling that entity to use your information. Third parties can access and compile and distribute and use your information in any ways you might even think are impossible. But you look for information in your cell phone, and when you reach your personal computer at your desk, you already have an ad campaign of what you were searching on your personal device. Sometimes you don't access or log in to your personal computer and you check it in your cell phone. You're just having an open discussion with your significant other and your family, and you open your device, and suddenly your search, without even searching, the first thing that comes to your interface is anything that you're looking for. Forget about accepting cookies, forget about it. I mean, it's very important. What I want to manifest and keep clear here is that the employer, as a stakeholder, as Maria said before me, the employers have a heart. The companies have rights. The employers and employees have rights. It's like the Jose Jose song, that's a Mexican singer, that's called 20 and 40. There's mandates and obligations on both parties and rights. That's the outline of general law in Mexico. I think it would be very important for us to be prudent and think about the use of personal data at the workforce, because the employer is investing and allocating budget assets, and they have a need, the employer has a need to control the relation, the labor relation that happens when the employee is subordinated. Under that subordination, there's a mandate of certain control, obedience, and responsibilities that's established and enshrined in the law. Think about the initial drafting of the initial laws. Which are the mechanisms? We need to outline clear policies, clear clear provisions or internal laws of the company about the use, abuse, and enjoyment of the information of the employers. I mean, we have to be capable of being transparent and communicating with transparency to all stakeholders, and communicate what's going to happen to the use of that data, with the use of that information. What's the level of use and consent of the use of that information? I mean, it's cookie acceptance. It's not an informed decision. It's not a decision with consent. It's like the employee must know where his or her information is going to be taken, where his or her information is going to be used. So the employee must be instructed or given knowledge about the situation of his or her personal information. How is that personal information going to be object of monitoring? There's another thing called, that's the privacy impact assessment. So they execute and go through the impact assessment of privacy before they implement new technologies. If you're going to use a new solution, a new program, the IPOL 2025 program, or that software is going to be implemented, I need to know the impact that that solution will have in the privacy of people. There's a software solution that's called Pegasus, that's used for espionage, that's used to simply eliminate dictatorships, autocratic governments. We saw this with Trump. We saw this with other executive branches in many countries. So we have to analyze, negotiate, and mediate with the workforce. It's always been that way. We have to discuss with the workforce what's feasible, what's not feasible. We have to instruct or educate the employees whose rights are being affected when their privacy is being violated. We have to train, we have to develop, we have to inform, we have to educate the parties involved, the employees and the employers, and measure the scope. Because you just common average people from all walks of life sometimes don't have an idea of what all of these means, what it all implies. They talk to us in another language. They speak to us in Sanskrit. They speak to us in English to communicate. They use tongues, but we have to constantly go through the review process of seeing what's happening yearly. We have to have a mixed commission constituted with both parties so they can sit down with specific frequency to analyze what's happening with the General Act of Data Protection. We have to audit and allocate budget to solve any dispute, to solve any litigation. What Gilbert mentioned is interesting. It's like, how do we draft the law? Each economy, each nation has its process to draft their general acts or laws. But the how, it's like this conference, this Inter-American conference can also disseminate this knowledge with its members or affiliated entities. How do we draft a thorough instrument that contains and bears the minimum rights of both parties, employers and employees, to protect privacy? It's the frame agreement or frame law that could be used in all the Spanish-speaking countries or in all the countries. It's an ambitious project, but we can have the general draft that has substantiation, that has clear grounds, clear definitions that could be replicated and used as the frame law for many countries. Thank you very much, Federico. And we have right now the time for your responses. I have in my record Maria and Estela, and I also like to keep in record who's part of the responses. Dr. Ulises also had a question that leads us to the closure of this initial discussion. He spoke about the mechanisms, and he said, which are the existing mechanisms that we could use to protect privacy in the entrepreneurial world in that context. So as part of your responses, we will compile this recommended mechanisms to protect, which are the mechanisms that we already have at hand as employers and employees. So it would be very interesting for us to listen to the debate with the answers to the formulated question that was also discussed and mentioned by Dr. Ulises Carmona. I have in my record here our professors Maria and Stella. Would somebody like to answer? Can you hear me? Yes, of course. Okay, I lost the connection with the in our session right now, and I didn't listen to the rest of the comments of Federico, and the rest of your comments were simply something that I could not receive. Don't worry, I'll repeat. I said that we had the records of your answers, Dr. Estela's answers, and Dr. Ulises' answers as well. So to give closure to the third question that was formulated, I think it's of all our interest to analyze the following question. Mr. Ulises submitted a question a few days ago. He was asking about the mechanisms that already exists. The answer to the how do we do this with the mechanisms that already exist that are object of our assessment in this initial phase. We have to detect the existing mechanisms. So as part of your responses, you could give us some guidance and give us some more specifications about the mechanisms that you have considered. We have in our record the participation of Maria, Stella, and Ulises as well. Thank you, Maria. Please go ahead, ma'am. As a mechanism, I agree totally with what Federico said. And the remedy, I base my answer in the model, in this mechanism. We have to draft the general frame of law, the general act, with all the substantiation of law, with the provisions that gives us a body of limits of lawfulness that regulates the workforce or the labor market. So it's very important for us to have a margin to continue opening this negotiation with the collective agreements, with the proper mechanisms between stakeholders and the other stakeholders to give this a solution with the mechanisms and with the proper frame and with the participation of Federico. You mentioned that important subject of the acceptance of cookies, and I'm public enemy number one against the acceptance of cookies. Don't take my comments as extreme comments. The cookies and the acceptance of cookies are very dangerous tools that have been invented, and Federico said it. If you, for privacy, to protect people's privacy in the workforce or out of the workforce, if you accept cookies, you accept with consent. In the European Union, is mandatory to accept the consent of the person that's the owner of the creation of the data. And when you accept cookies, I mean, there's many loops. I mean, we have the Cookies Act or the Cookies Law, and we speak of the same level of this field. So we can't just turn the page when we speak of cookies. It's like, so you can accept and give your consent and accept to that interface um, the cookies. I mean, as Federico said, try not to accept ever or the cookies when you go from one website to another. So it's that, and then we're going to have to pay to see that interface or that website. And January 1st, if we access a website, and I'm talking about 99% of the inquiries that happen in our law firm, when you access a site, our website, they have two options. You accept their cookies to continue navigating their website, or you simply have to pay to access that website because they modified their Cookies Act that enables like companies to take an extra share or charge a fee. And all the companies are betting on that. You can't, as a user, decide to accept or reject and give consent when you click on the cookies button. It's either with Meta, for example, with Facebook, if you don't accept their cookies, it's either you pay or you're accepting. You give your consent. It's either you're going to pay a fee or they're going to take your personal data, and that's what the company is going to sell to general strategic advertisement campaigns. And those are the mechanisms that the enterprises have that give us room to negotiate with the General Act for data protection. But when there's a website and the companies have those consents, when you click the cookies button, it's like you have to draft well the mechanisms and the lawful mechanisms to protect there. Thank you very much. Dr. Stella. I think that we were all caught by the comments of cookies, and my response is correlated to the consent when you click on the cookies button and accept it. I think you have to think about the formal compliance and efficacy of consent and acceptance. So with the cookies button, the user at the interface thinks that they're giving them the possibility to accept or not. When you're just giving just a minimum percentage of the capacity to decide, enable, click, or accept, or simply not accept what's necessary and what they're or what's not necessary, what's absurd here. If a person knows me, if I've enrolled and I start a search in any search engine, I type in my search. When I question or populate the field with a search, and in my settings, I specified that the thing or the interface kept or saved my settings. So why is my consent explicitly accepted and then that interface, it's like pops up that window and asks me to give my consent again. It's like the denial of the person's rights. It's the issue of cookies leads us to the same situation. Meta imposed that. So if you want your personal information to be object of sale or not, I mean, everything was quote unquote free. Your information is never free because they sell your information or trade with it permanently. But in that interface, they're telling you, if you don't want us to sell your personal information, pay us. And so you're investing. So where are you winning? Where are you earning something? If they're generating an income, a revenue, where's your share? If you don't want me to sell, then you have to pay me as an interface to simply not sell your data. And what ensures you as a payer of the fee to have your private information there simply being protected, as Federico said. So I know that we're just simple, down to earth people, that we're not parts of the god of the Olympus. We're a simple, common people being exposed. But which are the mechanisms? We have the outline general law, and we have to think about the international standards, the proper international standards, the provision that are object of interpretation, besides what our general acts contain. What Maria said, we have the Spanish Agency for Data Protection and its General Act of Data Privacy Protection. It's the enforcement of law. Maybe your law is not applicable in our region because your country is different to my country, but it could be replicated. But I follow this comment with this extra comment. As a region, we have to collaborate with other agencies and generate those partnerships and find the Iberoamericana Agency for Data Protection as an entity that contributes, and we can build and draft the principles, the guiding standards that are the backbone for us all. Thank you, Dr. Stella. Please, Dr. Ulises, the floor is yours, sir. Yes, thank you. It's very interesting. These subjects awaken our passions from the academia's understanding. It impacts our day-to-day lives. Everything that you've mentioned here leads us to analyze the loops, the gaps. There's the norm, there's the reality. The law is always being created to have an influence in the material world and the reality of things. But we have a lot of room and a lot of roads to pave down in our journey. I will reference, not specifically, but I'll reference some laws, and the internal protection of people's rights or the citizenship's rights are crucial. And the role that the administration or government administration and its agencies have are fundamental, as the executives or ombudsmen and women. We have the measures in Mexico to protect our citizenship. The National Institute of Personal Data Protection, called INAI in Mexico, is an agency that protects that. Federico also mentioned another subject that's very important for us. So what I think that the path that Federico mentioned is a route that we must explore. We can draft, we can create. I mean, I'm an external observer. I'm not a member of the works of the Inter-American Conference, but it's an entity that enables us to contribute with a transfer of knowledge. When we compare our laws, we're here to share our experiences. And with all of this substantiation and grounds, we can compile the best practices. We can compile all of the best ways and the lawful ways of reacting in all these economies. We must compile and consolidate an instrument that is the model the instrument that serves as a model. In it, we enshrine the basic provisions. Now, you've said this. What I'm going to say is something that you've said before. It's a very important document. It could be a major progress. There was a document drafted by the ILO in 1996 that's an object of reference. In that instrument, we have a set of guiding uh, compilation of laws that gives us the general frame to protect the employee's personal data. And there's another instrument that's a document of reference that we could use to draft another instrument. That's the instrument, that's the Protocol 16th of the Civil Committee that was constituted to protect rights at the United Nations. So with those two instruments or protocols, we can draft the other guiding instrument so we can be in compliance with the best practices and standards that we can compile based on our knowledge. There's a third instrument that could be also be referenced from the United Nations that's very important, that's being used to analyze or regulate companies and human rights. In the case of Mexico, the Human Rights Commission drafted in 2019 in the Nation's Gazette a protocol that has it's the protocol 37, or it's that reference instrument that we could also use and coexist. Major companies have their huge law firms that can draft huge instruments and contracts about these subjects. But as Federico clearly stated, what happens with SMEs, small and medium-sized enterprises that might not have the capacity that huge companies have? It's so important. That's why it's so important for the government to be a clear stakeholder that's present at ISTE, as other government agencies and authorities. So the governments have to be part of this debate so they can provide those guiding instruments, those A, B, C's, and D's that could enable all the different tier companies to participate in that creation. So I referenced these three instruments that could be a source. Now we have to protect internally and protect our rights at an international scale. So in Europe, we have standards or rulings from the European courts. We have those cases, the case law, the inter-American courts and rulings, and the ILO works are extremely important in our endeavors. So the human rights and these type of agencies can also contribute with their protocols, instructions, and procedures. But what Maria said is extremely important. There should be always room for negotiation. So we have to draft something that's tailor-made, custom-made. And I stress on that point. It must invite unions to be part of that debate. Thank you so much.
Thank you, Dr. Lises. And if you agree, to be able to answer the questions from the public of this debate that has been so interesting, I would close with a question to this round of discussions. And more than anything else, out of all the topics that have emerged that you as experts indicated us, what are the topics that are still pending? Because we cannot solve all of them in this conversation. So we have to see what other mechanisms can arise, what other pending topics to serve these conflicts among both rights between the right, labor law, and privacy. So I would like to give each of you, and I would like the participation of everyone, and to go to the Q&A round that is going to be supported in order to respond to them. I'd like to give the floor, and I have Maria, first of all. Please, Maria. Can you hear me? Because I don't know, something is being done, but I lose the connection and there's some vacuum. Yes, we can hear you well. We can hear you very well. Good. You can hear, we can hear you very, very well. Good. Can you repeat the question at the very end? So I have the first part of the question, I lost it. In order to close this part of the discussion, it would be very good for you to tell us what are the topics that are still pending to be responded with this conflict of both lost rights, and to have a second conversation in this regard about the mechanisms that have emerged in this discussion. Well, in my opinion, more I feel that they've touched upon all the matters related to this field of discussion, but I do feel that maybe this element or way of regulation will allow for lots of work and debates, being essential that we have to have the working environment with some of these fields, and where there should be a large margin to establish clear limits and elaborate or decide through a legal specific mechanism to allow for this negotiation and to allow for flexibility for the workers. This is my observations. So I have Dr. Stella. uh, so with what Maria said, so maybe this is a topic and the evidence of compliance, and then we don't talk about it, that is the accountability, what to do. So we're looking for the perfect scenario, but what we have, how can we really have this intention of complying in this balance that we all speak about and where we all agree, and how can we make use of these tools that today are very necessary with impact assessments and to value the human resources. So I think that applying this impact assessment, and we have to see that these employees, and I would say that with the privacy tools by design, policy by design, could be elements that complement everything that we mean. Mm. So I have Federico in the camera, and I spoke to you a week ago that I had to leave early. It's not going to be the case because they're calling me. But before I leave, I've enjoyed very, very much this chat and this debate with you to get to know you. And thank you, Assis, for the invitation. Pending topics that we left aside would be worth it to get into the points, the emails, for example. Now, this is so complicated, the use of an email. So this is a country where I never go, and they didn't let me in because I didn't have a credit card from that nation. I needed a credit card to get into that country. So every month I get emails from this place. I had to register with my email. So I get like 1,000 electronic emails every day of salespeople, people that want to sell me things. Another topic that is pending in work, the work is relatively new. In some countries, it's not so new. In others, is new. So we have to topic about telework and how do we protect personal data of remote workers and teleworkers and tele-employers. Digital platforms is a whole incredible topic regarding digital platforms in geolocations, those based in geolocations, and those that are based on the web, and try with this topic. And of course, communication through WhatsApp or Telegram, talking about the cyber pirates that take advantage, steal your data, and use false or fake profiles to request money, to extort people. We have many cases in some of the chats we have. Another topic that we still have to talk is emerging technologies. Technologies are continuous, are ongoing. We have to prevent. 100 years ago, we didn't know what was going to happen with technology today. Surveillance at work is important. and cybersecurity, and of course, social corporate responsibility. What is the responsibility of companies on the personal data management, and then the regulation, international regulation, studying similar cases, studying similar regulations, making a full comparison, an extensive comparison of where are we standing. And with that, I leave and I'm at your service. And thank you so much for inviting me. Thank you, Federica, for taking the time to connect. We know you're not in the country, so for us, it's a great honor that you, as a lawyer, are part of this conference. The honor is all mine. I'm fully honored. You have my information, my peers from the panel. Let's not lose this contact. Of course. Thank you so much. And from immediately, I have Dr. Gilbert in the camera. Thank you with your conclusions. Thank you. Thank you. The truth is, we could continue speaking forever because the topic is of great passion. And let me tell you what is still to be answered. Starting with the fact that this is a very complicated topic where there are intermediate parts and where we say that, and they show and conflicts arise. And this is what we have to avoid. Uh, we have to avoid both rights, work and privacy, both. So we consider that we should promote, first of all, a culture that would value the privacy and at work. And then this is a new culture that we have to work with. And then I think that to look into new, we've said there's a lot of problems that could arise, the violation or to of rights, and but if we have not responded, and some of you say what is important is the how. So here we could go deeper. And how can we promote this culture to treat, to deal with the resolution of conflicts that also has to be established in norms that, as we said, um, have to be a complete elaboration. If we cannot have these norms, legal norms of each and every one of the regions, then something internal. We have to establish how are we going to deal with these problematics. So conflict resolution is going to be done in great detail. Thank you so much, Professor Gilbert, and now Dr. Ulises, please. Yes, thank you so much, Maria Teresa. I also need to leave, so thank you so much. And Dr. Stella, she had to leave. Goodbye. Yes, Dr. Ulises, please go ahead. 2 points that are very concrete because we're running on top of the time. What is important is to get to know if everything fails, if prevention fails, if norms fail, if we cannot avoid conflict, that it happens, there is a problem with this right. So we have to think about the topic relative to the measures and sanctions and repairs. So of the effects, how are we going to remediate something when the damage already took place? What are the consequences that this could arise to? And secondly, if it makes or not a difference, and I mentioned it for every country, if we're talking about the relationships, working relationships in the private sector, and what the modalities or changes in the working relationship, talking about workers, what could they imply? Because it does make a difference. Our country is here represented by ISTE. These are two very important sectors, at least in Mexico, that are very well defined, but it also has different consequences. So talking about like in Spain, this is a different framework that can be explained to us by Maria, but our country does have a status that is different. And how can this have an impact in these other parts? This would be my comment. Thank you so much, Dr. Lises. And going to the Q&A session, we have a question. Dr. Marta Monsalve, that is with us and is part of our membership, would like to ask a question. Dr. Monsalve, we hear you. I would like you to enable the audio. Your audio is enabled. We're listening to you. Thank you so much. I'd like to congratulate CIS for this fantastic event and the guests also. And with regards to the fantastic topic proposed, it is true that surveillance and control on behalf of the employers towards its workers is mainly focused on a risk to privacy. This has been very present when when they established the right of disconnection. The only way the employer can know if the employee disconnects is by looking at him, her. So they have in their favor how important it is to have access to technology. So the employers can invest in technology to keep control if employees are going to connect or disconnect regarding productivity. Technology is very costly. And something else mentioned here are SMEs that will not have access to this technology that easily. So how can we look into these two economic aspects before a need of surveillance and control of employees, and at the same time, the investment, the technological investment that in these economic conditions ends up being very complicated? Thank you. Thank you, Dr. Marta Monsalve. I'm going to channel this question with Maria to see what does she have to do. What, and in case Dr. Lisa wants to add, please go ahead. Well, regarding, if I understand the questions regarding cost and control on behalf of the company, regarding the control at the time that technology intervenes, we have to take into account that, as far as I understand, that we have this these situation. It could be a remote type of work, or that is used in service granting, where we are not in the company physically, but it means remote work, as well as the use of a computer or a tablet or mobile phone of a worker that is going to visit a customer, that has to commute to see a customer, a client, and then come back. The movement of this device that allows control on behalf of the employer should not understand as a permanent control. That is why I was making reference of the classical changes of the entrepreneurial structure that technology has allowed. It's true that in the classic model, worker and the person is physically in the company office, but technology allows workers not to be there, of course, and that does not mean that employers can use these capabilities of control in order to implement the same model. In other words, this control has to be adapted to the new reality. And truly, companies try to keep permanent control of their labor as well as the work being done. And nowadays, this is not viable in most cases. That is why I was saying that every time we're tending towards a very important flexibility because we continue applying it, but it should not be so relevant to have the control of the time in the sense of the worker or the person that is working that should start at this time and end the work at this time. But it's more important to work according to goals. In technology, people have to change. And of course, this is being done slowly. And on the other hand, the costs in Spain, more than 85% or over 85% of companies are medium and small size companies. So that has an economic disbursement. But in the technological environment, it doesn't mean that the company is dedicated to the productive sector, that is dedicated, and maybe they don't have to do an important, very important investment. But any device, if we ask ourselves a mobile phone or an iPhone or a different brand, any brand allows you to use to make a call and connect and take pictures and use social networks. The speed of the processor depends on the device, but the cheap cost I was making reference to is that within all the technological investments that can be done through the cheapest and the most complicated, they don't necessarily have to do a quick disbursement because they could have an investment towards an external service that would manage all of this technology. That is what I mean, that costs are going to be cheap. And if I want to invest, for me, it has a higher cost. But if I want to benefit from a generic package of control of servers or control of example security cameras and data and is done by external company, I have a standard service. The cost is cheaper. So that's why I was talking about the generalization of technology and cheapening of technology, take into account that any technological investment implies expenditures, but this has great intensity for the company. Thank you so much, Maria. And maybe another panelist would complement the question if you wish to. If not, I would ask another question that we have in the audience that I also feel important and came out in this room. And they ask us, what are the collective negotiation margins for regulations related to information access of workers, given that the right of privacy protects people? I repeat, what are the collective negotiation margins for regulations regarding information access of workers, given that the right of privacy protects people? Well, maybe I would like to ask Dr. Ulises to answer, and then Maria, and then Gilbert could also respond. Well, the margins in general, I would say, are channeled through what we spoke about in this event. This is a human right. And of course, we should follow the three phases in negotiation and they should be looked into, and the state should do the proper surveillance. If these internal rules have to be followed, and the reason why, how we have a need of the measure, the proportionality of the media, so or the network. So this is a path. These are criteria that have been generated by the Inter-American Court for any type of restrictions of rights. And that is why I feel that unions negotiating or people individually should also verify so that these three vendors are complied with. So to safeguard the nucleus right, that if it's going to be affected or the right is going to be restricted is because of a necessary measure that is up to discussion because it depends what does the company do, what is this company, why is it needed for, and that this measure is also proportional, and that the person has a possibility of knowing and verifying what's the data being gathered, what is the use being provided using this data, and how can these data be corrected and eliminated. And sorry for being so generic, but when you weigh rights, you always need the concrete case to be able to say what is a weighing of each of the rights involved.
Agree, doctor. Would somebody like to contribute and answer? Please go ahead, Maria. Yes, well, I believe that here I could contribute. I think our the Spanish context and our perspective lead us to analyze the reaction amidst the negotiation of the collective that's broad, because we have to adjust the norm, and the norm has to adjust to the company. When we speak about the protection of personal data in the workforce, so we reach these agreements between the employer and the employees, first of all, to specify what's the use of the mobile devices that could be used by the company. They belong to the company, or if the devices are private. And in those devices, if they're private, the employee might give his or her consent for those devices to be used for the work purposes. So you can develop that. And second, we have to stipulate what can be done, what can't be done with those devices or those material resources, which are technology that's necessary for that relation to be built. Third, the controls in both context or conditions or assumptions. The device is personal or it's company owned. Those devices have to be negotiated with the stakeholders involved, and it's mandatory. And lastly, in a situation that's highly controversial, is the sanctions or penalties imposed to the employees if they're breached the compliance that's stipulated in the collective agreements or contracts. There's a sanction imposed to the employee, but we have to think about the sanctions and penalties to the employer. At European level and in Spanish laws, we have a system that protects and imposes sanctions when there's a violation of personal protection, the private data. The companies know what they're how they're going to be held accountable if they don't want that sanction or penalty imposed. In Spain, we have some cases filed with some sanctions that were important. You know, a small company had to pay 89,000 euros to the plaintiff that harmed the situation of the labor force. So this case, or this collective agreement, or this instrument that enables us to negotiate with the collective, gives room for us to compile a set of penalties or sanctions with any of the parties violate something, to escalate it to the courts if the company has a violation or materializes a violation on both parties, because the entrepreneurs or the enterprises consider that the norm has enshrined in its body what the sanction is if there's some violation or breach. Thank you so much, Maria. And Professor Gilbert, Professor, would you like to manifest or pronounce your statement, please? Pardon, I'm here with 10 mics. No, but the leeways or the margin that we have that was already mentioned by Mr. Lises, first of all, this what has to be upheld is the standards, the provisions, and I confirm that, reaffirm it. And in our case, here, I think that at a regional scale, when you negotiate with a collective, we have to start from the right grounds, the conventions, the collective conventions, and we uphold law. So there's the hierarchy of law. So we have to understand when we participate that through law, we have reached agreements as parties, as stakeholders involved, which the laws pre-establish the rules of the backbone. It's a group of laws, provisions of all these regulations that enable us to regulate the protection of privacy. That's all falls into that same frame of data protection with that convention, with our charters, with our constitutions, with what's enshrined in the 24th article. In the wording, you could read that there's the different court case resolutions, in the highest chambers with the highest authorities. They issue their sentences or resolutions about the cases here, and we discuss what's happening with ILO and international agencies and other entities. I mean, there's the frame. The margin of what we must do is still open, and it makes it all feasible for us. And we have to have collective will, or the parties' will, to reach those mid grounds. So we're here to work on protecting the workers' rights, the employees' rights, and the protection of the enterprises as well. This mechanism is the immediate mechanism that we have. So as a group, as a collegiate body, we have to build that law to generate a harmonious labor environment. It's not just after having said this, it's like we don't have to to find the silver thread, reinvent the wheel. We have all the instruments, all the available instruments, and the political wills and the wills of the stakeholders involved should lead us all to draft the best instrument, and that instrument should be of collective satisfaction, or for the satisfaction for the parties involved. Thank you very much. Thank you for answering our questions from our audience here present. Now we have exhausted the phase of discussion with our panel of experts. I only have one comment for our coordinator of experts, Luz Angeles Cardona. I will ask Angeles Cardona to give her closure announcement or statement before we adjourn. Thank you so much. Thank you so much, Maria Teresa, for moderating this discussion. Thank you all very much. Thank you, Maria, for being clear and open. Thank you for starting this dialogue with you sharing the Spanish experience. We thank Federico Anaya. We thank Stella. We thank Gilbert. We thank Mr. Carmona. And also, we thank Hernandez, Vianelli Lugo, who's representing ISTE, for all your participations. Thank you all for being part. The celebration of the closure of such a discussion that's been generated by experts in the field is very difficult to succinctly recap, to have a recap of all the subjects discussed. But it's very important for us to leave this door open for future discussion and debate, because we know that the privacy must be protected, and privacy at the workplace has to be protected. From the moment in which the employee is hired, we have to give the proper instruction and read the internal law and sign agreements, collective agreements with the workforce. They have to be instructed and know how to use cameras, cell phones, and material resources that are of proper use by the worker to consolidate that relations between the employers and the employees. And we think about the tracking, the data that's obtained when you hire as a company third parties that offer solutions, systems, or servers as companies. That's another point that has been object of discussion. And we have to be very mindful. We have to know which are the legitimate lawful restrictions in what's going to be drafted. As Federico said, all the employees have their heart, and the companies do too. So we have to protect the employees, and it's an open theme of discussion that coexists and correlates with the ways in which we establish the standards that guide our responsibilities as employers and employees. That gives us an opportunity, as it's been said by many and Estela today. We're very demanding when we speak of regulations to impose the protection of our privacy at the workplace, but there's a room and opportunity to discuss and debate, how do I, apart from the workplace, how do I protect my private information? And something that wasn't discussed at this table that I specifically think about subjects to be considered: what happens when a worker receives a suspension in the workplace? I mean, there should not be trace evidence of the person or the employee of his or her journeys, no trace evidence left behind in the devices. So it's not like the worker suspends his or her life. It's not like the worker is just apart from his routines and his personal activities. So if there's trace evidence in devices or journeys and other material resources, that's another subject of discussion. So let's be very mindful. A poor regulation of private protection could affect the stability of the rights of enterprises and employees. And this conference is discussing the labor stability. That's part of the essence of what we do in this institution. We're protecting the benefits and the social security benefits of the workers and the parties involved. So I think, first of all, I thank all the participants for being part of this session. This recording is going to be available for you in our digital content, and all your comments are duly noted. We're going to have the guiding instruments and other reference instruments that let us create a succinct work that's part of our endeavors. Maria Teresa, that's my final announcement. The floor is yours, Maria Teresa. Yes, thank you very much. For me, this debate was very interesting. It opens room to this line of work that was selected by the Inter-American Commission and this legal department. We've discussed this with the panel members. So they're going to draft our experts will draft papers of great interest regarding the core subject. As Federico also mentioned, we will have to continue our progress with all the member agencies of this entity that could help as a guiding instrument that could serve all the economies of the continent and all the member states. Our general director had to leave the session a moment ago, but I thank all the panel members for accepting our invite, for joining us, and I thank all the members of the audience who were connected and all the member states who are present. And as Ms. Luz said, this recording is going to be available in our digital content in 3 languages, in YouTube channels, and the micro website of the Inter-American Commission and the Department of the social and legal tab that we have. Thank you. I hope you have a wonderful weekend. Thank you all very much. Thank you all very much.